I am Bill Rochelle, Editor-at-Large for American Bankruptcy Institute. Today we report that the Seventh Circuit, I think once and for all, has set to rest the question of who comes out on top, a so-called DIP lender or a holder of a valid reclamation claim. Of course, I suspect you know what a DIP lender is. Typically, that is the secured lender who provided financing for debtors before they file Chapter 11 reorganization petitions. And typically, in brand new Chapter 11 cases, there is a so-called first day order in which the bankruptcy court allows what we call DIP financing. In substance, what that amounts to is that the bankruptcy court authorizes the pre-petition lender to roll over the pre-petition debt into a loan that is blessed by the bankruptcy court for the duration of the Chapter 11 case. And significantly, those DIP loans are usually what's called super priority loans, which means that they come in ahead of all other liens, even those that existed before bankruptcy. A reclamation creditor is, on the other hand, an unsecured creditor who provided goods within 45 days of bankruptcy. And the bankruptcy code established that a reclamation creditor is entitled to reclaim the goods. And so the question has arisen periodically throughout the life of our present Chapter 11 about who comes out on top. Does the DIP lender get to recover before the reclamation creditors, or are the reclamation creditors entitled to recover in full? As I said, I think the Seventh Circuit has put that issue to bed permanently because the Circuit Court said that the language in Section 546C that was modified by Congress in the year 2005 makes it crystal clear that reclamation claims are subordinate to DIP loans. Well, what that means for all intents and purposes is that in a case where the DIP loan is not paid in full, the unfortunate reclamation creditors are out in the cold and they really don't have any rights other than as just general unsecured creditors, which may mean that they get paid little or nothing at all, even though they supplied goods on unsecured credit within 45 days of the filing of the bankruptcy petition. Well, I am Bill Rochelle, and I will be back same time next week with something I hope interesting or important that has occurred in the area of bankruptcy law. Until then, be well and enjoy the spring.